Good morning. I'm Sherry Andrews, and this is Let's Talk Legal. I come to you every Tuesday morning at 10 with a little nugget for your business, some legal education just to keep you on your toes and let you know what might help you out in understanding the legal side of your small business. So today we're going to talk about copyright. Now, if you're here live with me, please drop a note in the comments so that I can say hello to you. And one other thing before we get started, if there is anything in your small business that you would like discussed on Let's Talk Legal, please drop me a note in the comments, whether you're here live or you're watching the replay. And I'll look into using that on a future Let's Talk Legal episode. So let's get started with the issue of copyright. What is it? Why does it matter? How does it affect your small business? So, under the United States Copyright Act, original works of authorship fixed in a tangible medium are automatically eligible for copyright protection. And that copyright protection uh, actually comes into play the moment your copyrighted material is fixed in a tangible medium. Now, copyright doesn't cover ideas in your head, thoughts, feelings. It covers something that has been recorded in some way. It applies to literary, dramatic, and artistic works. So, everything from books and blog posts to movies and videos to artwork and music. In this case, let's unpack it a little bit and talk about what it means to have an original work of authorship fixed in a tangible medium. First, an original work of authorship means that it's something that you have created, not something you've copied. So if you go to Shakespeare's plays and you copy off, three quarters of a play and put it, into a book, that is not an original work of authorship. Original works of authorship come out of your head, or they're you taking facts and figures and information and putting it creatively into a new form. Fixed in a tangible medium means you've taken it out of your head and you've recorded it in one way or another. That can be as simple as writing it down on a piece of paper. It can be typing it into a Word document. It can be creating a Facebook Live video or a blog post. It can be recording it on a camcorder, taking a photo, creating a painting. All of these things are tangible medium. So copyright covers an original work of authorship fixed in a tangible medium. What does that mean for you as a small business owner? Um, think about it in terms of marketing, your website material, your blog post. If you're like me right now doing a Facebook Live video, articles you write, courses that you create and teach, all of those um, are subject to copyright protection the minute they are fixed in a tangible medium. So the minute you've made them, you know, out of your head and onto paper or onto electronic media, your copyright protection comes into play. The part that doesn't get copyright protected is facts. So let's say that you are writing a blog post about um, a comparison of several different email marketing platforms. The information that you put into the blog post, like the names of the platforms, their pricing, their features, those are all facts. So they are not subject to copyright. But your creative expression, the way that you put that together, that information together, and your thoughts and feelings about it. So when you say, this works well, this doesn't work well, I liked this, I didn't like this, all of that is subject to copyright. It becomes important because, you create content, you create blog posts, you create courses. all of that becomes subject to copyright, and you want to make sure that somebody else isn't taking the material that you've created and using it for their own benefit. So, what happens once you've created your killer course and you're really rocking it if someone infringes it? Well, you have a couple of options on how to deal with infringement of your copyrighted material. First, you can send them a cease and desist letter. Basically, this is saying, hey, so and so, I know you took my material off my website and you're now using it pretty much verbatim to create your own course and you're selling it. And that's my copyrighted material. You can't do that. And you're basically asking them to stop and threatening them with a lawsuit if they don't. The next step is a lawsuit, but there's a wrinkle there. Your copyright protection in invest immediately in your copyrighted works, but in order to sue, in order to actually file a lawsuit, you have to have that copyright registered with the United States Copyright Office. That's something relatively, I shouldn't say relatively new. You always needed a registration to proceed full on with a lawsuit, but it used to be that there was a divergence of opinion between different federal circuit courts, and some courts would accept that you had filed the application to register your copyright and allow you to proceed with your lawsuit based on the strength of your application without actually having the actual registration complete. In March of 2019, the US Supreme Court changed that and said, no, in order to file a lawsuit, you must have an actual registered copyright. So at this point, if you find out that someone is infringing on your copyright, you have to have that registration in place before you can file a lawsuit. It's problematic for people who aren't regularly filing copyright registrations because the lag time between your application and actually receiving your registration is 6 to 9 months, sometimes as much as 18 months, during which you have to wait to file your lawsuit while this other party is still potentially infringing your copyright. The point of all of this and the application to your small business, when you have that blog post that gets, a lot of engagement and is being shared all over the internet and really got you noticed, you're going to want to go ahead and proactively file a copyright registration for that post. Or maybe it's your secret sauce formula for whatever it is you do. Say you're an email marketer and you've come up with a 5 step formula that's something that you created and you're now selling it as a course. Well, you may want to go ahead and copyright that course proactively so that others aren't stealing it, using it to create their own course, or when you find that there is somebody who has appropriated a large chunk of your material, you can proceed immediately with your filing of your lawsuit. I know that may raise questions, so feel free to put your questions in the comments and I will do my best to come back and answer them either within the comments or in a future Let's Talk Legal episode. So, this is Sherry Andrews signing off. Hope you all had a great holiday weekend and a beautiful week ahead. Bye.